Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. In a speech at a recent function organized by Prashant Bhushan's NGO and covered by Live Law, the well-known and highly regarded Supreme Court lawyer and former president of the Supreme Court Bar Association, Dushyant Dave, delivered a devastating critique of the Indian judiciary, the Supreme Court, and the Collegium system. To be honest, I, at least in my memory, have not heard such a scathing critique before. Joining me now to explain his views and why he felt a need to speak out in public is Dushyant Dave himself. Mr. Dave, as I said in that introduction, in a recent speech at a function organized by Prashant Bhushan's NGO and covered by Live Law, you delivered a scathing criticism of the judiciary, the likes of which has not been heard in public from any lawyer as far as I know. Today, I want to discuss some of the key points you made. First, you said, and I'm quoting, "We have a large number of judges who are highly questionable. They either lack the expertise or the knowledge, and most of all, the commitment." Are you saying that many judges simply don't deserve to be judges?
Karan, it's a very difficult thing to explain what is really the problem. The Supreme Court Collegium or the judiciary itself derived the power to appoint judges to the higher judiciary, High Court and Supreme Court in this 1993 judgment. And, the majority judgment by Justice Verma begins by saying what is the rationale that they wanted it. He says that these questions have to be considered in the context of independence of the judiciary as a part of the basic structure of the Constitution of India to secure the rule of law, and which is essential for preservation of the democracy. Now, these are very important three aspects: independence of judiciary, preservation of rule of law, and secure democracy. Now, this is really the fulcrum of the power that the judges, I would say, grab for themselves by rewriting the constitutional provisions. Fair enough. Now, you have done this, so that you wanted to, tell the world that, yes, we are going to make a judiciary which is fearlessly independent, which will protect rule of law, and which will really preserve the democracy. Question is, have you been appointing judges to the high courts and the Supreme Court over 4 decades in line of this fundamental principle on which your judgment is founded? My respectful answer is no.
I'll come to that in a moment's time because that's a very important part of your speech. But can you confirm, when you say, and I'm quoting you, we have a large number of judges who are highly questionable, they either lack the expertise or the knowledge, and most of all, the commitment, you are there clearly saying that there are many judges who don't deserve to be judges.
Look, again, I'll come to it. I mean, country must know that Supreme Court wanted in that judgment the judiciary to be free from political influence. 1. 2, they said we want judges who have, legal expertise, ability to handle cases, proper personal conduct, ethical behavior, firmness and fearlessness, and somebody who is fiercely independent. Now, these are the qualities which were very essential as part of that judgment. In my view, the large number of judges appointed in last 4 decades singularly lack either one of these attributes, and some of them almost all of these attributes.
Okay, that is very clear. Some of the judges appointed in the last few years singularly lack some of these critical attributes, and some of the judges lack all of the attributes. With that in the background, let me take up the part of your speech which looks like a direct attack on the Collegium. Citing the 1993 judgment which set up the Collegium, you said, and I'm quoting you now, it requires that we must pick the best available. Have they done that? Your answer is no, not in my view. And then you added, I have seen some of my colleagues at the bar being appointed judges in the last 10, 15 years, especially in the last 7, 8 years, who should not have ever been considered for judgeship. The kind of performance that they have today, the kind of judgments they pass, the kind of comments they make in the court makes me ask, how is it that the collegium system is failing in not considering this? You're clearly saying the collegium is not choosing the best or even the right people.
Absolutely. There is no doubt in my mind that collegium is compromising. And this is where there is a very serious issue. It's one thing that Collegium tried to tap the best talent available in the bar for appointment to the High Court as direct appointees, or even when they had to select from the lower judiciary, which they have to do because balance is almost 50-50 in High Court from the subordinate courts and from the bar. My own thinking is that judges have not considered, even offered to appoint those lawyers who really deserve to be appointed. I know of tens and tens of lawyers across the high courts in the country who are outstanding young lawyers with 20 years of practice at the bar and who could have been easily considered for high court judgeship. They were never sounded. They had large practice. They were very proper in their behavior. They were very competent at the bar, but none of them have been cited. So it's very surprising that the Chief Justice of a High Court, when he is considering, because he's supposed to know the personal traits of a lawyer when he considers the nomination, and therefore he should really ask the best lawyers that, do you want to be judges? He didn't do that. He hasn't been doing so up till now. And as a result of that, the high courts have not got the best what it should get. And that was your command. That was your mandate. Best from those amongst available. You have failed.
But it's even worse than what you're saying, because it's not just that the best are not being considered. As you point out in the quotation I read earlier, people who are inappropriate and nowhere near the best, who should never be considered for judgeship, those are your words, end up becoming judges. So the best are not being considered, and the mediocre and the ordinary who shouldn't become judges are becoming judges in their place.
There is no doubt about the fact that the best have been left out of consideration. There is no doubt about that. And that's why and it's not that, today it's not that we don't have competent judges. We are talking about, we are talking about some of them. I mean, judiciary consists of even today outstanding judges. So you can appoint, and you have been appointing good judges. You do consider, but when it comes to, overall view, it appears that you do not take into account the best. And that is where the problem arises. Because if you appoint those who are not the best, they get a life of 10, 15, 20 years judicial life. And for those 10, 15, 20 years, the country does not get judges who are willing to protect the rule of law, who are willing to ensure that democracy is preserved, who are not willing to ensure fundamental rights are protected to the hilt. So that's a big problem.
Absolutely. And in fact, you cite in particular the example of Chief Justice Muralidhar. You say, and I'm quoting you, in my view, Chief Justice Muralidhar's place is only the Supreme Court. He is one of the most outstanding judges in every sense of how a judge should be. But he's not even able to get a good high court, you add. And the Collegium, you say, is sitting twiddling its thumbs. Now, unfortunately, many laymen and laywomen will not know the Muralidhar case. So can you briefly tell me where in your eyes did the Collegium go wrong in the Muralidhar case?
Well, Justice Muralidhar, was hearing, I think, the Delhi riot case, and he felt when the case first came to him, as soon as the riots had broken out, that the police was not acting properly and it was not taking action against the real culprits. And till today, they have not taken action against the real culprits, as we have all seen, because some of the people, including the ministers and members of parliament, made most provocative statements which led to the riots. Justice Muralidhar wanted action to be taken, and promptly the Collegium had him transferred within no time to Punjab and Haryana High Court. And that was a clear act of punishment of a good judge for doing something for protecting, the constitution, the rule of law, and the minority community of this country. But he was punished. He was then transferred to Orissa as the Chief Justice, mercifully. But then his transfer has been effected to Madras High Court, which is a premier high court. And for last many months, that transfer is not being allowed by the central government for reasons which are obvious, because central government wants to punish this particular judge. How dare he speak, order and action against our political members? And that's exactly what happened in the case of Chief Justice Akil Qureshi. It happened in the case of Justice Jayant Patel from Gujarat, who was in Karnataka number 2 judge, and Collegium transferred him as number 7 or number 8 judge to Allahabad. All these judges were singularly picked up thanks to Collegium at the instance of the executive, and punished again and again. So,
and in each instance, the Supreme Court or the Collegium stood by and did nothing. That's why you say...
No, Collegium was party to it, not stood by. The government has no power to transfer. It is the Collegiums which did it. It is the Collegiums comprising of some of the good judges also were party to this decision of punishment. And it really sent, these kind of transfers, this kind of, non-consideration for promotion sends chilling message across to the judiciary that judges, beware, do not do anything against the ruling party, because if you do so, then we have Collegium with us. We will ensure that you are punished. That's the message.
I want to underline what you said. It wasn't that the Collegium failed to stand up. The Collegium was party to the punishment that was being given to the 3 judges you mentioned, Justice Akil Qureshi, Justice Muralidhar. So the Supreme Court was complicit because they were participating in the process of punishing these 3 men.
Yes, far from asking the government, why should they be punished? The Collegiums facilitated it. And it was really sad to see. And some of the good judges who were part of the Collegium stood by and did not protest.
Now, you in fact go one step further in the examples you cite. You spoke in that speech of a recently appointed judge in the Supreme Court, and you said he has not written a single good judgment in his entire career. I know you won't name him, and I'm not going to ask you to name him either. But I'm going to ask you, do you really mean that there is a sitting judge in the Supreme Court, the highest court of our country, who hasn't written a single good judgment in his entire career? You really mean that?
Well, he may be sitting, he may not be sitting. I'm not going to go into that. But I can definitely share with you and with the viewers that there have been large number of judges who have been appointed in last, several decades, who have not really contributed to development of jurisprudence as high court judges, who have not really given good judgments interpreting the constitution, interpreting the fundamental rights, protecting the democracy, or showing fierce independence which is required of them. They have many judges who have come to the Supreme Court have come because they buckled under the executive's pressure and did not do what they was expected of them as judges. So there are judges who really are being considered by the Collegium of the Supreme Court for elevation on considerations which are completely outside this judgment. You see, this judgment of the Supreme Court is their Bible. You cannot go outside that Bible or Gita and start appointing judges merely because you have power to do so.
Can you clarify something? You said there are many judges who are being considered for appointment to the Supreme Court. Have they actually been appointed to the Supreme Court, even when they clearly do not deserve to be? Have there been judges appointed by the Collegium to the Supreme
many.
Court?
Yes, many. And Karan, you must understand, I have been a lawyer since 1978. I came to the Supreme Court in 1986. When I came, we had outstanding judges, in Supreme Court. Judges like Justice Bhagwati in terms of intellect, Justice Pathak, Justice Chinnappa Reddy, Justice D. Desai. I mean, to name so many judges thereafter came like Justice Jivan Reddy and Justice J.S. Verma, Justice Venkat Chalaya, Justice Ahmadi. I mean, you name, there were dozens and dozens of judges who were of world-class caliber. Now, over last 3 decades, you are finding that judges who have come are really, so I would say, are not strong in their expertise of law. One, they are not strong in interpreting the constitution. They are not strong in their, striking at the executive arbitrariness.
Okay.
What is required? Today, you need a Supreme Court judge who will tell the government that you are wrong. This is absolutely arbitrary action. This takes away the fundamental rights. We will strike. There have not been many. And in recent years, as you know, many judges have faced question marks in the Supreme Court. I don't want to name, but many judges have faced question marks in the Supreme Court. You go to the corridor of Supreme Court and ask lawyers, you will know that they have been very unhappy. Unfortunately, nobody wants to stand up and speak about it. We all suffer in silence.
This brings me to the second critique that you make in that speech. And this time, it's a critique not of the Collegium, but the Supreme Court itself. You say, and I'm quoting you, not once has the Supreme Court exercised the power of contempt since 1993. And then you add, this shows that the Supreme Court is afraid of taking the executive head on. Now, when the Supreme Court is scared of taking the executive head on, it's clearly failing in its constitutional duties, because constitutionally, the judiciary and the Supreme Court, as the head of the judiciary, is on par with the executive. They have the right to take it head on when they feel there's a need to do so. If they are afraid to do so, it means they are failing in their constitutional duty.
See, let us look at it this way. If you and I had a case in Supreme Court and you have won the case, and I am not implementing that case, supposing it's for vacating your house, I am your tenant, you will file a contempt petition in Supreme Court and Supreme Court will send me to jail for failing to comply with his judgment, saying that you have not vacated Mrs. Thappar's house. Now, you have taken the view, right or wrong, in 1993, in the second judge's case. You have said that what we say is final. At the most, government has one opportunity to come back to us and tell us that this particular nominee to Supreme Court or High Court is not worthy of being appointed for the following reasons. But if we disagree with those reasons, and if we reiterate, you are bound to accept our recommendation. Now, if this be so, government has been playing around with the Collegium in number of cases for last 20, 30 years and have not been appointing, very well considered judges or nominees to Supreme Court and High Court. And yet the Supreme Court Collegium has been sitting silent about it. As of today, large number of names are pending with the government. Large number of names. When government finds the names are suitable to them, their names are cleared by government in less than 24 hours. As we saw with Justice Hemant Gupta of Supreme Court and Justice M.R. Shah. But there are other judges who have to wait for months on. And there are some whose names are never approved by the government. Now, why so? So that is where if the judgment of the Supreme Court is the law of the land, which it is by virtue of Article 141, then everybody, including the government, is bound to implement. If they don't implement, only consequence is contempt. Why is it that the Supreme Court remains so silent? So it's compromising with the government.
And your article actually suggests an answer to that question you just asked. Why is it that the Supreme Court remains so silent? You point out in that speech that Narendra Modi is a strong prime minister, just as Indira Gandhi used to be in her time. And you say the Supreme Court clearly does not want to question him. But then you add, and this is very important, unless we have a judiciary who is willing to question, day in and day out, it will be failing. But if you have a judiciary who's scared to question the Prime Minister, Narendra Modi in this case, then not only is the judiciary failing, it's actually sending a message to the country: we're subordinate, we're weak, we can't stand up and question the Prime Minister. And that is a message that fundamentally undermines the concept of justice as well.
It's not about Mr. Narendra Modi. He is undoubtedly the Prime Minister, and he is undoubtedly a strong man of this country. And he is the most popular Prime Minister, whether one likes it or not. But what is the effect today? The effect is across the country. You find that in BJP-ruled states, there is hardly ever a question about corruption in public life. None at all. Nobody is being questioned, much less investigated, and certainly not arrested by ED or income tax or CBI. You go to the opposition-run states, you find that leader after leader is being investigated, is being implicated, is being prosecuted and arrested, and they find themselves in jail. Now, in all these cases, what is happening, unfortunately, is that the judiciary is not able to see through. I am not for a moment willing to condone corruption by anybody, be it opposition or the ruling party. What I feel is that when judges see that systematically opposition is being targeted in this country by using the central agencies, the judiciary has to wake up to that and remind the government enough is enough. Okay. Stop. This is not good for the democracy. This is where our power is. We grabbed this power to maintain rule of law and preserve democracy. We therefore now injunct you from taking these kind of actions. So that is something which is very troublesome, where judiciary has really, I would say, fallen short of expectations from many of us.
We're sliding into the examples you cite in that speech, and I want very much to take up 2 or 3 of those examples. The first is, in fact, to do with bail. You say no bail is given even in the simplest of cases, even to comedians. And then you point out opposition leaders are being arrested on flimsy grounds, sometimes for purely bailable offenses, but they are not getting bail from lower courts, from high courts, and often even from the Supreme Court. And you add, this is very, very alarming. When the judiciary fails to give bail, particularly when they fail to give bail to either comedians who have been poking fun at the government or to opposition leaders who the government sees virtually in quotes as enemies, then this is another example of the judiciary failing to stand up to the executive. It's another example of the judiciary being cowed down and scared.
See, there is no doubt that the exercise of power by the judiciary across the country, especially in cases relating to members of the minority community, the Dalits, the opposition leaders, the critics, and stand-up comedians et al., I think it's far from satisfactory. And in most cases, we find that the judiciary has failed to protect the liberties of these group of citizens. They must understand that every day's liberty is important, and you can't deny. I mean, take, for example, Bhima Koregaon cases, for example. I mean, you can't just keep people languishing. Take the example of this journalist from Kerala who was going to cover this story in Uttar Pradesh. After 2 years, he gets a bail. I mean, there are such hundreds and hundreds of cases, whereas you find that people who have made most obnoxious and seditious speeches targeting the minority community and the opposition leaders who have been arrested as a lip service are being released by the judiciary within 24 hours. So, I mean, is this the kind of a judiciary that we want? I mean, last week, I think I had a case in Supreme Court where a particular Muslim cleric was being sought to be arrested. He came for anticipatory bail, failed to get it in trial court and high court. And the charge was that 15 years ago, somebody else had tried to convert some people by luring them with money, and their children were studying in his madrasa. Now, Supreme Court gives me anticipatory bail, but in the next sentence, Supreme Court says that it will be open to the investigating agency and the prosecution to move the court for custodial interrogation if it is needed. So I had to tell Supreme Court that what you gave me with left hand, you are taking away with your right hand.
It's even worse than that. It's even worse than that. It shows that the Supreme Court at the end of the day doesn't even have the courage of its convictions. They give with one hand, take away with another. And that reminds me, when you said even one day's denial of liberty is unacceptable, that's precisely what Justice Chandrachud, before he became Chief Justice, said in the Arnab Goswami case. It's not the principle that applies to Siddiq Kapan, and it's not the principle that applies, and this is something you point out in that lecture, to the treatment of Muslims. And you add, and you said this, by the way, with the greatest of passion. I'll point that out to the audience. That's one part of your speech where you spoke with enormous passion. You said, judges are unable to stop this. Muslims don't get bail for months or years. And you explicitly then cited the example of Shah Rukh Khan's son, Aryan Khan. Even though the FIR made clear that no drugs were found on him, he was denied bail and kept in jail for almost a month. And you pointed out that the High Court initially endorsed this. And then you said the magistrate who had denied him bail should have been suspended. No action has been taken against him. And that clearly shows that the judiciary is not keen to correct this denial of justice that is repeatedly happening. One example would have been sufficient to correct it, but they haven't acted.
Well, I think I would stand slightly corrected. The magistrate and the Sessions Court refused him any relief. And in fact, they gave him to police remand and extended the remand. The High Court, when a matter went to the High Court, and I mean, in fairness, the High Court gave the order ultimately. And that was something which was really good and commendable that the High Court did. But yes, the magistracy and the Sessions judge both failed us. And that's disastrous because they could never have ordered such a man against whom there is nothing, no allegation, much less evidence, to send him to jail like that, and that too to a police remand. I mean, it was, I would say, disgusting to see that. I mean, take, for example, the hijab case. The hijab case, Supreme Court, 2 learned judges differed and said the matter should be sent to a 3-judge bench almost 2 months ago or 3 months ago, maybe. I mean, it was the duty of Chief Justice Dhananjay Chandrachud, to, as master of the roster, to have immediately fixed this matter for hearing, because, women are being denied right to education. Women are being denied right to enter into examination halls because they have chosen to wear a hijab. Now, I mean, for a Chief Justice not to be conscious of it as master of the roster is a matter which really surprises me, if not saddens me.
But very quickly, just to clarify for the audience, you do believe that the magistrate in the Aryan Khan case should have been suspended, and that is a step that the judiciary should have taken to ensure that this sort of, in quotes, deliberate error does not ever happen again. That you did say.
Every day, judiciary expects the bureaucracy, when it fails to discharge its duties, action should be taken against them, and gives big lectures. So why does judiciary remain silent when its own judges do not follow the law of the land, and they don't follow Supreme Court's own judgments? So action has to be taken. How else will you send a message? How else will you send a message?
Absolutely. I want to come to one more example from that lecture that you gave. This time, some people would say it's a very radical example. You were speaking clearly with Maharashtra in mind, although you didn't name the state. You said, when the ruling party weans away MLAs to topple opposition governments, the only response from the Supreme Court is to order a floor test. And you added, this is hypocrisy on the part of the judiciary because they know that the floor test will fail. Instead, you said, this is an occasion for the Supreme Court to be innovative and to say that those who left the state by going deliberately to Assam should not be allowed to vote. They should be first asked to contest a new election. Until then, the old government will be allowed to continue in office. Now, that was a very novel, innovative suggestion, but a very radical one. Do you really believe the Supreme Court should have gone to this extent to ensure justice?
Look, it's very important. Why is it that an MLA is important? An MLA is important not just because he's a member of the Legislative Assembly, but because he represents lakhs of people from his constituency. So these people have voted him with certain aspirations, certain hopes, certain ideology. Now, when he, fails them in these hopes, aspirations, and ideology, they have a right to be concerned about it. They didn't vote for him so that he can go from one party to another. There is a 5 years period for which people have elected him to be. Now, what happens is, see, what Mrs. Gandhi did was completely wrong. She encouraged, dissolution of many state governments. She encouraged, fall of many governments. It was wrong. BJP said so time and again. When BJP came into power, BJP promised a better public life, a better, rule of law. And they said that we will not do what had happened in the past. Today, therefore, what is important is that how can you ever have a real test when, let's say your party in power has 100 MLAs, opposition party, and they are running the state. You win over 20 or 30 of them, which is less than what is the requirement of the 10th schedule of the Constitution for an actual legal or constitutional defection. You lure them away. They go in a private jet to Assam or Karnataka or somewhere and are put in a 7-star hotel with police all around, central paramilitary forces guarding them so that even their families can't contact them. What is it being done? That they are being hijacked to ensure that they don't go back to their original party. Then you go to the governor and say that the state government has lost its majority, therefore order a floor test. Governor is naturally the nominee of the central government. He tells the chief minister, go for a floor test. When he comes to the Supreme Court says, no. You go and face the floor test. We will not, stop the floor test because that's constitutional requirement. Because democracy means floor test. But at that stage, Supreme Court is ignoring what is really happening in the country. They are not sitting in ivory towers. The judges know what is happening. Judges know why these MLAs have gone away. They know that they are lured away. We are talking about figures now of 50 crore, 100 crore and things like that. I don't know the fact, but these are the rumors which we hear. Now, if this is happening, the judges have to really be innovative to protect the real democracy, not this artificial democracy. So judges then have to say, we will not allow a floor test with these people participating. Without them, we will allow a floor test. If they want to participate, let the election be held within 2 weeks or 4 weeks, fresh election in their seats. If they come back, with the new party now, newly, sworn party, they can vote. So that is the real meaning of democracy, to preserve democracy. Otherwise, judges are actually encouraging corruption in public life by, their, I would say, traditional and outdated approach.
There are 2 more questions I want to ask you before I let you go, Mr. Dave. In that speech of yours, you said, nobody wants to speak about the issues that I'm raising. The bar is silent and the collegium goes on as if everything is hunky-dory. Is that why you decided you were going to go public? Is that why you did something that hasn't been done, as far as I know, by any other lawyer? Express your concerns in fairly stark, sharp terms and with a lot of passion. Is that why you went public?
Look, there are many reasons why I speak as I do. You must understand. It's not that I don't love judiciary. I love judiciary, and I respect judiciary immensely. But when I walk in corridors of Supreme Court, I realize what is happening. The young lawyers are facing serious challenges in their practice. The rich and the powerful are able to get justice in court very routinely, whereas the weak and those who are powerless are not getting justice very quickly for many reasons. I don't want to describe those reasons just now. But systematically, I have been feeling that judiciary is becoming weaker and weaker from within. They can't blame anybody from outside because they are appointing themselves. Therefore, judiciary is becoming weaker and weaker for myriad reasons. And as a result of that, what is happening is troublesome. And it is only because of my love for judiciary, my love for country, and my love for constitution, and also my love for my fellow colleagues at the bar, whom I really, admire, who cannot speak because the young lawyers are unable to speak. The senior most lawyers somehow don't want to speak. So I would say I am trying to give a voice to these people who are unable to, have a voice because they are not strong enough to speak up.
My last question, and we have only a minute. Are you at all apprehensive that having spoken up and spoken so sharply, with such passion and so critically, that there could be repercussions you have to face?
No, I'm not apprehensive at all. See, when I decided to, adopt a role of a critic, I did it consciously. I knew that it will impact my practice immensely. I knew that it will sometimes impact my social relationships also. And I knew it may even impact my, reception before certain judges. But I must say that I have got, that's the kind of a sacrifice that I was prepared. And God has been extraordinarily kind, because I started with 250 rupees a month. And for first 2 years, I shared an apartment with a High Court peon. So, I have never forgotten those days. So I am very clear about what I want to do. If I can contribute even a little bit towards, a better country, better judiciary, better rule of law, then I think my life would be really worth it. I am not apprehensive at all, because I get huge love and affection from young members of the bar. And I must say, a lot of good judges have a lot of regard for me and respect for me. Yes, there is always there are people who perhaps are little immature to misunderstand you, and they say many things about you. They try and sometimes give you threats, etc. But there is a God, and these things don't really worry me beyond a point. I enjoy what I do.
Let me end by thanking you for speaking up. It is in the interest of our democracy, and ultimately it's in the interest of our judiciary and Supreme Court, that the truth be known, that criticism be aired in public, because that is the only way things will be corrected. We're running right out of time. I want to thank you for this interview, and I want to thank you for opening the eyes of the country to a situation which otherwise we might not have found out about. Take care. Stay safe.
Thank you very much.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.